Say something. No.
You can't hear me?
No.
Yeah, now.
You can't hear me.
Thank you.
We are on the record in multiple forfeiture cases. Today is an oral ruling on motions to dismiss. The state will appear in all of these cases by one Assistant Attorney General, and that is?
Annie J.
All right. When I call your name, would you indicate that you are present? In 13 FO 3028, there are 1, 2, 3, I think, 3 citations concerning Kelly Albright. In 13 FO 2685, Adam Chern. In 13 FO 2759, Emily Catherine Hope. As to Andrew Hunt, 2 cases, 13 FO 3045, 13 FO 2705. In 13 FO 3057, Amy Noble.
Amy Noble appears by Jordan Love as well.
Thank you. And I expect counsel to jump in.
Hello, Adam Chern appears by Patricia Hamill.
Thank you. Have I reached your client yet? You don't know.
And I no longer try to say something.
All right. 13 FO 3058, Bruce Noble.
I say something. He's my client.
All right. Is he here?
Yes, he is.
13 FO 2726, Christine Peterson. 13 FO 3061, John Riggs. 13 FO 2737, Mary Sanderson.
She had sent a letter saying that she would not be present due to a work conflict.
Okay. I'm going to rule on her case even in her absence. 13 FO 2754, Jan Tamura. Is that your client?
No.
Where's?
Pro se.
Okay. All right, so we have everybody. The starting point for today's ruling would be Article 1, Article 1 to the amendments to the United States Constitution. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press. The Wisconsin Constitution contains a similar provision, and that is, every person may freely speak, write, and publish his sentiments on all subjects, being responsible for the abuse of that right, and no laws shall be passed to restrain or abridge the liberty of speech or of the press. So let me end the suspense and state what will happen today simply. In March of 2011, I was the judge who, by some media reports, actually from this seat in this courtroom, threw the protesters out of the Wisconsin Capitol. Following that decision, people actually applauded me for doing that. So today, I am throwing out this administration's attempt via this illegal administrative rule to silence those who disagree with it. Let me be clear, a permitting system for controlling conflicting access to the Wisconsin Capitol can be devised that meets the requirements of the First Amendment and the Wisconsin Constitution. But the rule that brings us here today fails to meet long-established standards concerning First Amendment principles. And let me also indicate that 1 week from today will be D-Day, and we are a free society because of what happened on D-Day. And you probably all know that that was the day that the Allied forces invaded France to free it from the tyranny of Nazi Germany. As I said, in March of 2011, there were thousands of people in the state capitol. That was my case. I entered a ruling, and then Chief Tubbs cajoled the people occupying the capitol to leave. He no longer is the chief of police for the capitol. Via EMR 1305, bypassing the normal rule procedure, the governor announced an emergency. The effective date of the emergency was April 16th, 2013 through September 12th, 2013. The finding of the emergency included the following preamble. Groups of persons continue to occupy rooms in the Wisconsin State Capitol without permits, including the Capitol Rotunda. These groups constitute an exception to the norm. That rule and its subsequent enforcement is what brings us here today as to all of you, council accepted. That rule prompted a lawsuit by the American Civil Liberties Union on behalf of one plaintiff, Kissick. Now, the American Civil Liberties Union is known to cause trouble for state, municipal, and the federal government when it comes to abuse of citizens' First Amendment rights. On July 8th, Judge William Conley found a portion of the rule unconstitutional. I adopt, as if it were my own, the ruling and reasoning of Judge Conley in his July 8 decision, and I will later on in this decision adopt the ruling of Judge Markson, my colleague on the Dane County bench, in his, we will call them singer protester cases. So, it should be obvious that those of us who graduated smack in the middle of our law school class benefit from the wisdom, intellect, and analysis of our colleagues. Despite the fact that the rule was found wanting by Judge Conley, the administration pressed forward and arrested you. And those arrests started in August 15th with Mary Sanderson and ended on September 6th with Andrew Hunt. That lawsuit needs to be mentioned, was settled on October 8, 2013, when the Department of Administration paid to plaintiffs' counsel, including the ACLU, $88,270.80. However, the administration felt that they could cobble together what was left of their rule, combine it with Judge Conley's ruling, and still pursue prosecutions. The emergency rule, now known to all, but I think I should cite it for a proper record, read, sub 2, in order to preserve the order which is necessary for the enjoyment of freedom by occupants of the buildings and facilities, and in order to prevent activities which physically obstruct access to department lands and buildings, or prevent the state from carrying on its instructional, research, public service, or administrative functions, and pursuant to section 16.846 stats. Whoever does any of the following shall be subject to a forfeiture of not more than $500. V, in parentheses, without approval of the department, conducts an event in those buildings and facilities managed or leased by the department or on properties surrounding those buildings. Sub VM, in parentheses, any participant or spectator within a group constituting an unlawful assembly who intentionally fails or refuses to withdraw from the assembly after it has been declared unlawful shall be subject to the penalties identified in sub 2. Any event may be declared unlawful if its participants, and this is sub 5, enter or occupy any building or facility managed or leased by the department without authorization. And the protocol for continuing to enforce the ruling that had been questioned by the federal court was as follows. A signboard was set up that said, if we determine that your event is larger than 20 people and you do not have the required permit, we will declare the event unlawful. If participants do not move outside or disperse, they will be subject to arrest. Part of the protocol also involved a broadcast message that read as follows. Attention in the Capitol. This is the State Capitol Police Chief David Irwin. I have determined that your group or event does not have the required permit. I am declaring this an unlawful event. Please move your group outside or disperse immediately. If you do not, each participant is subject to arrest. And so that's why you are here today. Now, in retrospect, one can reflect that had you simply waited until September 13th of 2013 to exercise your First Amendment rights, you could have done so with impunity because the emergency only existed between April 16th, 2013 and September 12th, 2013. But you all wouldn't wait. You wanted to exercise your First Amendment rights during the emergency period, and that's why you got arrested. However, based upon the ruling of Judge Conley and what I am about to refer to as Judge Markson's ruling, all of these citations in each and every case are and will be at the end of this dismissed. Judge Markson and others observed that the continued prosecution of you and hundreds of others was done without amending the rule to arguably make it pass constitutional muster. In February of 2014, Judge Markson ruled that all of the citations in front of him needed to be dismissed. And what he stated was this: the police issued Michael Crute, C-R-U-T-E, his defendant, a citation for not having a permit when he participated in a sing-along in the Capitol Rotunda. Mr. Crute moves to dismiss the citation. He argues that the permit requirement violates the First Amendment because it applies on its face to very small groups. It is therefore not narrowly tailored to address the legitimate interests of the government in requiring a permit. I agree and grant the motion. In other words, having been told that their rule was unenforceable, They didn't change it to make it enforceable, instead tried to mush together the remnants of the rule and the federal injunction. Judge Markson found that procedure unconstitutional and dismissed all of the citations in his court. He said, for our purposes, the import of Kissick is clear. The rule is unconstitutional on its face. If amended to provide a reasonable numerical floor, that would solve the constitutional problem. At the time that Mr. Crute was cited, and all of you, the rule was not so amended. It remained facially unconstitutional. We need to go no further. An unconstitutional law is a legal non-entity, and he cited case law to that effect. He went on to say that because the rule is void, those citations had to be dismissed, and there is nothing more to be decided. He expanded on that by saying, the Kissick court had no power to make or remake an administrative rule. It did not do so. The Kissick's court preliminary injunction was a way to balance temporarily the competing interests. The court's ruling must be respected, but it is not self-executing. The state never amended the rule to conform to the preliminary injunction. If the state wished to penalize citizens for speaking and assembling without a permit, it was required to do so under a rule that is unconstitutional. So, as to State of Wisconsin versus Kelly D. Albrecht, all cases against you are dismissed. As to Adam Chern, your citation is dismissed. As to Emily Catherine Pope, your citation is dismissed. As to Andrew S. Hunt, your citation is dismissed. Both of them. As to Amy Noble, your citation is dismissed. As to Bruce Noble, your citation is dismissed. As to Christine Peterson, your citation is dismissed. As to John Riggs, your citation is dismissed. As to Mary Sanderson, your citation is dismissed. As to Jan Tomoric, your citation is dismissed. Now, in other cases, the state has appealed the rulings of judges who have ruled as I have ruled today. Let me ask the state, do you know if there will be an appeal of this ruling?
That's not my decision, but I will be forwarding it on to the people whose decision it is.
Okay. I am not allowed under ethical rules to give any unrepresented defendant legal advice. However, if the state pursues an appeal, some of you might think that vindictive. That's not for me to say. But you could be required to defend the dismissal by writing a brief in the Court of Appeals. Those of you who are unrepresented may find that a difficult, time-consuming task.